everyone. My name's Kate Silburn and I own Rocky Mountain Elder Law. And today I'm going to tell you a story about someone who perhaps was taken advantage of while he was alive, because certainly what happened after he died was deeply unfortunate and tragic. During his lifetime, this person was a very successful engineer. After his wife died, though, he was very isolated. And during this period of isolation, a neighbor befriended him, a younger woman who took him to doctor's appointments, made meals for him, kept him company, but she also did something else. She secured an attorney to do his estate plan. Now, this gentleman already had an estate plan, but she felt he needed a new one. And not surprisingly, upon his death, what emerged was a pattern of her getting him to change not just his will from his children to her, but also all the beneficiary designations on his accounts to her. In fact, he even beneficiary deeded his house to her. So when it came to light after he passed away and the will was submitted for probate, that she was the beneficiary of pretty much everything with the exception of small cash gifts to the actual children, it was very apparent to the children that this person had probably unduly influenced their father and had created a will that was the product of undue influence. Now, this may sound far-fetched, like that couldn't possibly happen to my father or me or my mother or my grandmother, but unfortunately, these types of scenarios are quite common. Someone who is not a family member or maybe a distant family member, estranged and then ingratiates themselves to somebody, and suddenly there's a whole new plan. Suddenly there are beneficiary designations that don't correspond to anything that had been done previous by the person signing the will. So we want to really think about what are the causes, what led up to this. Oftentimes it's isolation and loneliness. Oftentimes it's a sense of, this is the only person paying attention to me. So I really want to caution families about keeping track of their parents, being part of their parents' lives, understanding what is in their parents' estate plan. If their parents don't have an estate plan, getting one done where everybody is on board and the process is transparent. Otherwise, what happens is the little story that I told you, and that leads and culminates into oftentimes a trial on the merits of the will, whether or not it will stand. Sometimes they do stand. Sometimes courts find that the testator had capacity and was estranged from their children, and this will is valid. It's very difficult, and it's a very high evidentiary bar to overturn a will in Colorado, even under such facts as these. So this is sounding a note of caution in your world, and know that if you have questions about planning or about the potential for litigation, please call Rocky Mountain Elder Law so that we can have a consultation to discuss anything that might be amiss.